Hey, so we're going to go over the exclusive seller brokerage engagement agreement, basically your listing document. I'm using this one for an example because this is actually one of my rental properties. It's just kind of easier to find this one. And if it's going to be auto filled out, because that's what DocuSign likes to do, then might as well have it on my own personal one to be able to be used. So this is very similar to the buyer brokerage agreement, yet it has some changes. And again, it's very good to know backwards and forwards because it's going to be very similar to the purchase and sale agreement in which the seller will receive. So you always want to start off by letting them know just kind of how this is constructed. One, it's drafted by the attorneys and the committees that make up the Georgia Association of Realtors. Um, and these are pre-printed forms in which we are licensed to fill in. So you got section A that has all the basically the blanks for the terms, and that will match section B. As you can tell, we're already on our third page before we get to B, the explanation point. So again, A1 matches B1. So going forward, for and in consideration of mutual promises contained herein, and good and valuable consideration, the seller and the undersigned broker do hereby enter into this exclusive seller brokerage engagement agreement for the buyer to exclusively represent seller in the listing and selling of the property listed below for sale on the terms and conditions set forth. All right. So you're hired exclusive, representing them on just the listing and the selling for the terms and the conditions, basically your roles listed below. So we've got the property information, and it's the address. As you know, going through the real estate school process, the address and the city and the tax parcel is not enough. You absolutely, it's good practice to go ahead and find that warranty deed or a deed of some kind that's on record. Not that I don't trust other listing agents to do their job, but it is also our job to verify. Well, sorry, that had to do with talking about other listing agents. That had to do with writing the contracts. Sorry. Not that I not that I don't think that our sellers are on the up and up, but it would be good to go ahead and have that warranty deed pulled. It also lets you know how many signers you need to have. Sometimes they forget, oh, this person's not on the mortgage. That's great, but they're on the deed. They also need to sign. So just a lot easier and a lot less room for error if you just always make it a habit to find that deed book in the GSCCCA website versus the deed and the lot information. Of course, it's obviously a lot different if it comes into the units. Now, where you could get messed up is you have like 9 out of 10 of these filled out correctly, but you fill out one blank wrong. Again, good error of judgment is always pull that deed for the exhibit. So the list price, a price of which property shall be listed for blank. Commencement date, this agreement shall commence and be effective upon when both parties sign off. The ending date has to have an ending date. It can be 3 months, 6 months, whichever you choose. It could be a year. I know sometimes with land, it can be up to a year. This shall be the last full date of the agreement after which is terminated and shall no longer be in effect. These are the different MLS sites in which you will have the property listed. This agreement, look how it's in bold. This agreement must be timely delivered and listed with the above referenced multiple listing services in accordance with the rules. This obligation shall control over any conflicting or inconsistent language. I have the date that it's going to go on the market as of October 14th, which is ironically today. This shall be the date in which the property is first marketed to the public. Seller shall have the right, upon notice to the broker, to move this date up or back, but not more than 10 days. So really that allows you to not have to have a amendment of any kind. So if the weather is, off or the pictures aren't done or whichever else. But again, upon notice to broker. And this allows you to stay compliant with the contract. Compensation to broker. So Keller Williams, our Woodstock office, and what will most likely be adopted by our Blue Ridge office. We are no longer doing co-op. So this section, I'll get to it. I'll come back to it. So compensation to broker is negotiable and not set by state law. However, this does not obligate individual licensees and brokerage firms to necessarily negotiate their compensation. So just like the BBA, it's not a monopoly. It's not a set in stone across the board, across the state, across all agencies. However, it doesn't mean that we have to negotiate what we feel our worth and value is. Seller agrees to pay seller's broker the following compensation at the closing of the contract. So we agree to pay what I feel, it could be, I'm going to write 3 turtles. I agree that we're going to get paid 3 turtles at the time of closing. Again, because I own this property, I'm not paying myself. So then it says optional, optional, optional. Seller hereby approves the following compensation. If any, being paid to buyer's broker by either the seller, in addition to compensation being paid to the listing agent, or the seller's broker is going to pay the buyer's broker out of their compensation that the seller's giving them, or the seller and seller's brokers are going to set forth. So either the buyer broker is being paid directly by the seller, or the buyer broker is being paid by the seller out of the seller broker's amount. So like what we've seen in the past, you're either getting paid a full 6 turtles and the buyer's broker is receiving 3 of those turtles. Well, now they're telling us that they don't want it to come. This is a co-op situation and they no longer want to see that. It needs to come directly from the seller themselves. So that's why we were putting 3% paid by seller. This section here, I've got NA. If there's separate compensation, if seller leases the property and enters into a lease agreement, seller shall also pay broker a separate leasing compensation in the amount of course, in this situation, it's not applicable. The length of protected period shall be, I typically write in 90 days. That's my personal. You can do 30, you can do 0. Obviously, this is my personal property. I'm doing 0. Every other document, I'm typing in 90. So that's same thing with the buyer brokerage agreement. These are the relationships that we do and don't offer. So we do not offer sub-agency. It's the only one we do not offer. If broker offers, and I go into more detail about that on the buyer brokerage one. If broker offers dual agency as one of its agency relationships, which we do, seller does or does not consent for broker to act in a dual agency capacity. This is a conversation between you and your client, whether you're representing them on the buyer side or the seller side. When you get to this point, it's that conversation. And also it could be it could be a comfort level thing for you too. Some people like to know that you would never represent the other party, that you always have their back and you're looking out for them. And others are like, I've done this before. It's not my first rodeo. I don't care. If the other side doesn't care, I don't care, kind of thing. Just have that conversation. Because you're representing the seller on this aspect, there's a lot more disclosures that have to be shared. Lead-based paint, if the house was built in 1978 or is older, we have to disclose that. Now let me read this. Federal law requires disclosure of lead-based paint in homes or a portion thereof constructed prior to 1978. So this means if that mantle, that the house, they renovated it, they brought in this shabby chic mantle, if it was from a house back in the 30s, we absolutely need to have a lead-based paint. There is so much expense with getting this lead-based paint disclosure wrong. That is absolutely best to have your bases covered. and to add that lead-based paint. And that's something that you want to have your seller fill out prior to going on the market, prior to an offer, because it has to be dated and the seller's signature and date has to be before the buyer's, because you're disclosing this information to the buyer. All right, seller has the following special circumstances that will require third-party approval before seller can do the following. Now note, this is not in the buyer brokerage agreement, which is interesting because it's good to know if your buyer is going through a separation, a divorce, anything along those lines. So the sellers to notify you if they're going through a bankruptcy, a divorce, in order, they've filed for divorce, or they're going through short sale and they're going to need, approval for that. Seller not on title. All of that needs to be shared and noted. So when you're sitting in front of your seller, that's just something that you're kind of like going through the check boxes. Hey, you're not, you've not filed for, or you're not going to file or have filed, just kind of working your way down the list. Seller does or does not authorize the broker to assist, to the extent requested by seller, in negotiating the terms of and filling out a pre-printed form contracts for seller's review and approval. It's very different. But again, there are transaction agents out there, so it would be nice to kind of know if they do or don't approve, to be able to negotiate or fill out those forms for you. So again, this goes in a little bit more further definition. Seller has the full authority to enter into this agreement for the listing of seller's property. This agreement may not be amended except for in writing by the seller and the broker. Failure of the parties to adhere strictly to the terms and conditions shall not constitute a waiver of the right of parties later to insist on such strict adherence. Seller is not a party to any other exclusive seller agreement, either that has not expired or not renewed. Seller acknowledges that seller may have to pay a previous broker compensation if they are subject to a past broker engagement agreement, or they've terminated, etc. So this is again CYA letting them know, section 1, they may be subject to a compensation later. Seller agrees to list the property for sale at the list price specified. It actually tells you the failure of the property to be shown or sell at the list price may be an indication it's listed too high. If the property is under contract to sell, and that term is defined below, but the listing period expires prior to closing, the listing period shall automatically be extended to the closing date. Same thing as buyer brokerage agreement. If during the term of this agreement, seller and prospective buyer enter into an agreement on the property, or contract to exchange, or option sale, etc., basically it's not compensated, the listing period may be extended unilaterally by broker for the number of days that the contract was under, the number of days that the property was under the contract to sell. Again, but broker has to provide written notice to the seller within 5 days. So they were under contract for 33 days. So that basically shortened their listing agreement by 33 days. It did not close. So if broker gives notice in writing to the seller within 5 days, they can extend the life of the listing agreement by those 33 days that they lost. Marketing. It's nice to be able to go over this with your seller so they fully understand in black and white, in fine print, and also to let you know, hey, you're about to commit to do this for your clients. So broker is authorized to market and advertise property for sale in any media a broker is choosing, including the internet, multiple listing services, and attempt to procure buyers for the property in cooperation with other real estate brokers and their affiliated licenses. Seller acknowledges that in listing the property on the MLS, all members of these MLS services and real estate related third parties will have access to their listing information, including images, recording, and their right to use all available technology to create, download, store, supplement, manipulate such listing information to assist seller in the sale of the property and for tracking and analyzing real estate transactions. That covers your MLS, that covers all of those parasitic sites such as Zillow and Redfin and all the things, and they're pulling their information off of those sites. As such, broker may not always have control over aspects of the marketing of the property. Again, Zillow, how it lists it, what it posts, if the square footage is wrong on Zillow, but accurate in MLS. Any media created or purchased by broker to be used in the marketing effort shall not belong to or be the property of the seller and may not be copied, reproduced, or used by seller or third parties without the express permission of the broker. You can't be terminated and that seller say, hey, I want my pictures of my house. It's my house. You own that information. Seller warrants that any and all media provided or paid for by seller is the property of the seller. Okay, typically it doesn't happen. Typically, you as the listing agent are paying for those photos ahead of time. Seller agrees to indemnify the broker for any claim by a third party related to the use of the provided media. Broker shall not be allowed to use seller provided materials during the term of the agreement with any third party for the purposes of marketing the property. And seller acknowledges that broker shall not be liable to seller for the continued use of media by third parties after the termination of the agreement. Seller agrees not to place any advertisements on the property or to advertise the property for sale in any media except with the written consent, consent. Broker is also hereby authorized to place a broker's for sale sign on the property. If the property is sold or a contract to sell the property is entered into during the term of this agreement, the broker may advertise the property in any media choosing as being under contract, with a sale as pending and as being sold upon the closing of the property, etc. So that's kind of, again, CYA, it allows you to do that unless you write a special stipulation that states this seller does not agree to for sale signs. This seller does not agree to any of that was listed. So it is a good thing to go ahead and read through such that they approve it and agree to it. Seller agrees to remove any personal property prior to the listing of the property if they don't want images of it to be captured. Broker shall not be liable to seller if other brokers or buyers take photographs, videos, or other technology to capture and manipulate images of the property without permission of the seller and broker. So a buyer walks in and takes additional images. We're not liable for that. Broker agrees to file this agreement with the above referenced MLS within 1 business day of the marketing commencement date, which shall be the date the property is made available to the public. Marketing of the property to the public includes, but not limited to, here we go, flyers displayed in windows, yard signs, digital marketing on public-facing websites, broker websites displayed such as IDX, digital communication marketing, email blasts, multi-broker listing, sharing networks, MLS, and applications available to the general public. Internal marketing that only goes to other licensees within the seller's broker's firm is not considered public-facing unless it's distributed to them outside of the brokerage. Seller acknowledges that the MLS is or is not a party to this agreement and is or are not responsible for errors or omissions on the part of the seller broker. Seller agrees to indemnify services from against any and all claims, liabilities, damages, blah, blah, blah. Seller acknowledges that by virtue of listing the property in MLS, all MLS members and their affiliate licensees will have access to their listing information for the purpose of assisting seller in the sale of the property. If sellers on a do not call list, they expressly consent to broker calling the seller for any purpose related to the sale of the property. This shall survive the termination of the agreement. A lockbox may be used in connection to the marketing. There have been some isolated incidences of reported burglaries in which lockboxes have been placed and for which the lockbox has been alleged to have been used to access the home. In order to minimize the risk of misuse of the lockbox, broker recommends against the use of lockbox on door handles that can be unscrewed from the outside or other parts. Since prospective buyers and others will have access to the property, seller agrees to remove all the valuables, prescription drugs, and or keys and put them in a secure place. Seller is encouraged to communicate the availability of the property for sale to friends or other acquaintances. However, since broker has been hired to exclusively market and show the property, Seller shall not, with respect to the sale, prepare and distribute market materials, hold up in houses, put up signs regarding the property, create websites, prepare flyers, brochures, or videos, or engage without the written consent of the broker. Compensation obligation. In the event the seller enters into a contract to sell or lease back, seller agrees to pay seller's broker compensation at closing. Seller shall have no obligation to pay the compensation of the buyer's broker. End of sentence. However, some sellers approve such compensation being offered and paid for either by the seller or the seller's broker. If seller has agreed to pay compensation, it shall be paid in at full closing. If seller does not approve, then the buyer shall be solely responsible for paying. And then the same thing about lease. Protected period. The protected period shall be from the period of time set forth in this agreement upon the expiration or unilateral termination of this agreement, which broker shall be protected for its compensation. If agreement is unilaterally terminated by seller without the consent of the broker, the protected period shall be the number of days remaining on what would have been the original listing as of the date, plus the amount of days set forth in the protected period. For instance, if you have a listing for 6 months and they terminate at 4 months, you still have 2 months. Let's just call it 30 days per month. So let's just say that's 60 days. And you have a 90-day protection period. So you were protected those 60 days and the additional 90 days. If they were to relist with someone else, close, you are due your compensation according to this. There shall be no protected period if broker and seller mutually, both sign the document, terminate this agreement. In that event, during the protected period, seller enters into a contract to seller during the period of the agreement. Seller shall pay buyer broker at closing and the commencement set forth. In the event that during the protected period, seller enters into a contract to sell forth or lease the property during the term of this agreement was submitted to, identified or shown to any buyer, was provided specific information about or inquired about the property, either directly or through the broker working with the buyer, then seller shall pay broker at closing the compensation. Notwithstanding, if this agreement expires, an exception to the above compensation obligation shall apply and no compensation shall be due, owing, or paid. The exception shall not apply if the agent agreement is unilaterally terminated by seller compensation rights. Oh, gracious. Notwithstanding, if this expires and is not unilaterally terminated by seller, an exception to the above compensation shall apply and no compensation shall be due if seller enters into a contract to sell or lease to purchase any portion of the property during the protected period by or through another licensed broker with whom seller has signed an exclusive seller brokerage. So if it naturally expired, it wasn't a termination, and they relisted it with somebody else, they are not due compensation. This again discusses a little bit more on agency and how we, unless noted, we offer all of these agencies except the sub-agency is not as marked. And then talking about the dual agency disclosure. And this shares if seller and the prospective buyer are both represented by the same broker and the broker's not acting in a designated, then the seller's aware that the broker is acting as a dual. Seller has been advised that in serving, the broker represents both parties, whose interests are or at times could be different or even adverse. Broker will disclose all adverse material facts relevant to the transaction. Does not have consent. Seller does not have to consent to dual agency. The consent of the seller is given voluntarily. Seller hereby directs broker while acting as a dual agent to keep confidential and not reveal the information. They have to timely disclose the nature upon signing. Seller's consent to dual agency conclusively deemed to have been given and informed if they sign off on this. So the exact same section as the buyer brokerage agreement. Designated agency disclosure. Seller does hereby consent to broker acting in a designated agency capacity. No adverse. Broker has no other agency relationships with the parties. Lead-based paint as required by federal law. Any portion of the residential dwelling built prior to 1978 is hereby attached as an exhibit. The term residential dwelling includes any painted fixture or material used therein that was built or manufactured prior to 1978. So it's 1978 and older, not just 1977, prior to 78. No, it's 78 and older. The sale of the property is contingent upon the third party approval, talking about special circumstances and short-term, what was it? Oh God, what was it? My brain is completely blanked. Short sale. There we go. It shall be the seller's responsibility to seek to fully, to fulfill any contingency and ensure that the purchase and sale agreement is made subject to such contingency or condition. Broker agrees to keep confidential any information that seller asks them to keep confidential, except items that are required by law. Seller acknowledges, however, that the buyer and the buyer's broker may possibly not treat any offer made by seller as confidential. Broker may not knowingly give customers false information in the event that there's conflicting information of not giving customer false information, and of course, keeping the information confidential of the seller. Not giving false information will prevail. Negotiation, broker may assist in negotiations. Seller property disclosure statement. Georgia law requires that the seller disclose known latent defects in the property, which could not be observed by buyer upon a reasonable inspection. This is the case even if the property is sold as is. So there is an exhibit called Disclosure of Latent Defects and Fixtures Checklist that can be used if they have not lived in the property. So it says in writing, within 3 days of the date of agreement, seller agrees to provide broker with a current and fully executed either seller's disclosure statement or, like I mentioned, latent defects. Broker is hereby authorized to distribute the disclosure to buyers interested in the property. Seller agrees to promptly update the disclosure documents through the closing should any changes occur. So like, let's just say you go under contract, you get the house inspected, you are disclosed information about the property, and it terminates and you go back on the market. The seller is obligated. Well, wait. Nope. Seller agrees to promptly update the disclosures should any changes occur or new knowledge is known, basically. In caps, seller acknowledges that the broker has no duty to inspect the property for defects, hazardous conditions, repairs of any kind. Seller owes a duty of reasonable care to keep the property safe for prospective buyers and their agents, invitees, contractors. This duty includes a duty to warn all such persons of dangerous conditions that would not be obvious. To minimize seller's potential liability, seller is encouraged to correct all hazardous conditions on the property. Seller agrees to indemnify and hold broker harmless from and against any and all claims, causes of actions, suits, and damages arising out of or related to being injured or harmed on the property. CYA, seller acknowledges and agrees that broker may show other properties to prospective buyers, shall have no duty to inspect the property or advise buyer or seller any matters of all of these items. Review of this agreement and transaction by an attorney, tax consultant, etc. Among other things, we don't know the zoning or the propensity of the flood or the flood zone. Seller acknowledges that broker does not perform or have any expertise in any of the above tests, inspections, or reviews. Seller shall seek independent expert advice. Seller acknowledges that broker shall not be responsible to monitor, supervise, or inspect any portion of the construction or repairs to property, and that such tasks fall outside the scope of real estate. Seller acknowledges and agrees that broker shall owe no duties to seller, nor have any authority on behalf of the seller other than what's set forth. Shall make all disclosures required by law, shall not be responsible for ensuring that seller complies with the duties and deadlines contained in any contract to sell entered into by the seller, and that the seller shall be solely responsible for the same, meaning the sellers need to be adults and be responsible for themselves and their deadlines. Seller shall be indemnified and held harmless by seller if any claims, causes of action, damages, arises from inaccurate or incomplete information provided by seller to broker, earnest monies handled by someone other than broker, seller's negligence or intentional wrongdoing. Seller acknowledges and agrees that broker any loss or theft of valuables, prescriptions, keys, etc., is not our fault. The existence of undisclosed material facts about the property of the transactions, not our fault. Any damage or injuries occurring on the property as a result of dangerous or defective conditions, not our fault. Or the failure to secure or restrain pets, not our fault. Shall have no authority to bind seller to the contract. We can't lock them in to a purchase and sale agreement. In bold and caps, seller acknowledges that broker shall under no circumstances have any liability greater than the amount of compensation paid herein. Shall have no liability in excess of $100 for any loss of funds resulting in wire cyber fraud. Same thing on the buyer brokerage agreement. If we are to come across anything fraudulent, we have a duty and a responsibility to report it. Same thing with the seller. Miscellaneous arbitration, assignability, attorney fees, broker, definition of seller and buyer, exactly the same thing in the buyer brokerage agreement as well. Disclaimer regarding the sale of certain property, talking about the aliens and not being able to sell to them within 10-mile radius of the military bases and military airports, which is kind of new. Entire agreement. This agreement represents the entire agreement of the parties with respect to listing the property for sale, intended to supersede all prior written and verbal agreement of the parties. No representation, statement, promise, or inducement not contained herein shall be binding on any parties. This agreement shall be binding on the heirs of the seller. Yes, it happens. Sometimes sellers pass away before their properties sell. Fair housing, seller acknowledges that broker is committed to providing equal housing opportunities to all persons, and that seller and broker are obligated to comply with state and federal fair housing laws in selling the property. Seller and broker agree not to discriminate in the sale of the property on the basis of race, color, religion, national origin, sex, familial status, disability, sexual orientation, or gender identity. Unless seller is a foreign person, seller shall deliver to the closing attorney at closing the foreign investment, indicating that the seller is not a foreign person. The GAR forms, again, the Georgia Association of Realtors and their committees are the ones that come up with these contracts. Governing law interpretation, this agreement may be signed in multiple counterparts. They still have full force and effect. Independent, we are not an employee of them. Seller acknowledges and agrees that with regard to any property which seller intends to sell, there shall be no knowledge imputed between broker and broker licensees, or between different licensees. Broker in each broker's license shall be deemed to have only actual knowledge of such properties. Notice between seller and broker. Again, communication. Seller and broker agree that communication notices between them regarding the term shall be in writing, signed by all parties, etc. Referrals. Seller acknowledges and agrees that broker may receive a valuable consideration if they refer them, or relocation for services outside of their area. Statute of limitations, the 2 years, survival, third-party vendors, time is of the essence in A. Brokers' duties and sellers' duties. And in the default, we're almost done. Broker shall promote the interests of the seller by seeking a sale price at the price and terms stated in the agreement. However, broker shall not be obligated to seek additional offers to purchase the property while the property is subject to a contract to sell, unless broker engagement so provides. Broker shall promote the interest of the seller by timely presenting all offers, even when the property is subject to, so even when the property is under contract, we are to timely present all offers, all offers, all offers. Disclosing to the seller material facts in which broker has actual knowledge concerning this transaction, advising seller to obtain expert advice as to material matters which are beyond the expertise of the broker, timely accounting for all money and property received in which the seller may or may have interest. Broker shall keep confidential all information received by broker during the course of the engagement, which is made confidential by an express request from the seller. However, the disclosures between broker and any broker's affiliated licensees assisting broker and representing the seller shall not be deemed a breach. Okay, so if you're sharing it amongst agents in which you're working, like perhaps you're on a team or you're working together. Seller agrees to cooperate with broker to sell the property, make the property available, provide accurate information, comply with the laws, and carefully read all the contracts and comply with all duties and deadlines. Seller shall be in breach of the agreement if they terminate prior to the end. Broker removing the listing from the multiple listing, taking down the broker's sign, ceasing to market the property, shall not be evidence of the broker's agreement to mutually, but shall instead be merely an acquiescence by broker of the unilateral. So again, back on the buyer brokerage agreement, if it was a unilateral, the agent was still due compensation. If it was a mutual termination, or both buyer and agent signed off on it, then they weren't going to be due compensation. So this is basically stating that just because they take down their sign and they cease to market it on the property or whatever, it doesn't mean that the broker mutually terminates with them. It just means that they understand it's a unilateral termination and they're to cease. Defaults under contract to sell the property, resulting in the contract not closing. If the seller agrees with the buyer of the property to terminate the contract to sell without the consent of the broker, basically going behind their back. Or the seller refuses to accept a lawful, bona fide written offer to purchase the property with the following terms. So if you receive an offer and the seller refuses to accept it, and it was a purchase price after fees and costs and contributions that would have given the seller a full listing price and is to be paid in cash or equivalent, or the offer is not subject to any contingencies, conditions, due diligence periods, etc., or the offer is not subject to seller warranties and representations, etc., or the meeting the following terms and conditions. Okay, so it actually has to hit all four of these. And the last one is the date of the closing is not less than 30 days and not more than 45 days. So basically, if they refuse to accept a lawful bona fide written offer that hits ABCD terms, then you are owed a compensation and they're in default and they're in breach of the contract. All of those happening is kind of a unicorn. Broker remedies for seller default. Seller shall immediately pay the broker the compensation for any of the seller defaults, except for seller unilaterally terminating this agreement prior to the end of the listing pay. And with respect to the event of default, seller's obligation to pay broker its compensation shall be controlled by the protected period of this agreement. Seller default in the event seller defaults under this agreement, seller shall, in addition to other obligations, hereby reimburse broker the out-of-pocket expenses and costs incurred by broker. Such costs and expenses shall be included but not limited to printing, copying charges, mileage at the highest rate allowed by the IRS. Seller shall also pay all costs, fees, and charges for removing the listing. The payment of these costs, fees, etc., seller shall not waive or limit broker's right to assert any other claim. On and on and on. Definitely something to go over with them so they understand here is your exit, and please know if you default, this is what happens. And they forget that until they try to exercise that. Again, talking about cyber beware fraud brochures is always a great idea to go ahead and give them copies of the brochures. You do want to have exhibits attached to here, such as the legal description, definitely the lead-based paint, et cetera, et cetera. Have it, go ahead and have it all attached and signed off on. And have them sign. And again, this binding box, once all the parties have signed, you're gonna have the date and the time, and you want to make sure that they put in all their contact information so that you can again communicate and provide notice moving forward.